So today I'm going to talk about British common law. We've talked about the Italian Codice Commerciale, and we've seen how, everything has got to be defined and written down, etc. But in British common law, it's very different because the sources come from the judges' sentences, and their principles which are made in these sentences. Normally, a lawyer, to understand, what principles there are in the commercial law in England, they have to go to the past cases. But there is some statutes. We've got statute law which are written by politicians, and normally we know laws as being produced by the Parliament. But like I say, much of commercial law in England comes from sentences which are made by judges and contain principles in them. Many years ago, lawyers would have to try to understand and try to work out what principles these sentences were contained in these sentences, so they could predict what would happen in their cases, and then they could advise their customers who they were defending or acting for. But now, the judges make it very obvious what the principles to apply should be in all sorts of situations. So the sources of commercial law in England are mainly this jurisprudence. So this jurisprudence, case law, which is basically sentences of courts. A principle is a court must always follow a statute first if there's one present. So if there's common law and then the politicians write a law, obviously the written law prevails, written by the politicians, because they're the representatives of the public, not the judges. But if the statute doesn't exist, then the lower courts must respect the higher courts' sentences, the precedents set by the higher courts. So it is quite predictable for the lower courts, because normally they just follow these precedents. And for a lawyer to understand what the law is, he has to go to the precedents and has to look at the past cases by the higher courts, and then say, during the trial, he could say this is the precedent and this is the law, and should be applied in this way, and the court must follow that if it's appropriate. Used to be the House of Lords was the highest court in the land, but now it's the Supreme Court. And the House of Courts, it was much, a lot of them are ex-politicians, ex-prime ministers, ex-representatives of the public. So, in a way, it was ex-politicians establishing the law for a lot of this common law. Now, we're going to look at a case to understand this common law and the principle that come from the sentences. We've got to look at a case. It's best to look at a case. And this is Donahue versus Stevenson. This is the law of tort. So this applies to commercial law, but also to any, private law, any, public law, it's not just compartmentalised into private and public. So this is basically negligence and can be applied to all sorts of situations and different branches of law. This sentence, every solicitor or trainee student solicitor must get to know this for the law of tort. So everyone gets familiar with this case. So Mrs. Donahue was consuming a ginger beer bought by her friend in a bar. That's important. It was bought by her friend, not by Mrs. Donahue. The ginger beer had a decomposed snail in it. Mrs. Donahue only noticed the snail after she had drunk some of the ginger beer, and then she was very ill. Now, Stevenson is not the bar. It is actually the manufacturer of the beer. So you've got Mrs. Donahue, who wasn't the buyer of the beer, and the seller was the bar, which isn't the defendant. The defendant is the original supplier and supplied the bar. So there was no real contract between Donahue and Stevenson. You know, there was no offer and accepting of an offer and exchange between these Donahue and Stevenson parties. So the question is, does Stevenson have to pay a compensation to Donahue for this damage that she suffered from the negligence of this snail being in their ginger beer? And what the principle the court came up with was yes, in fact, it doesn't matter if there wasn't a contract. There is a duty of care owed towards our neighbour. So this, you know, the language neighbour, we can see in our Christian culture. You know, we must love our neighbour as ourselves, is in the Bible. And they talk about a duty of care towards our neighbour. So this is basically, we've got to love our neighbour. So we can see this principle emanating from our cultural inheritance, heritage. The second question to answer is, who is our neighbour? So, you know, are they neighbours, Stevenson and Donahue? So do they have a duty of care owed to each other? And the court defined neighbour with a neighbour test, and the neighbour test was let's have a look. So, a neighbour is someone so closely and directly affected by my act that I ought to reasonably have them in my contemplation as being affected when I am directing my mind to the acts or omissions in question. So this really does create a legal text with this principle. You know, there's acts or omissions, and the neighbour is somebody who could be affected by these. So the judge came up with this idea of a duty of care and towards your neighbour, and the neighbour is anyone who could be affected by your acts or omissions. And that really does mean that Donahue and Stevenson has a link, you know, and there is a responsibility, an obligation by Stevenson towards Donahue. So damage should be paid for the consequences suffered. Now, another principle can be established by another case, Caparo versus Dickman in 1990. So Caparo buys Fidelity PLC shares with the intention of taking it over. So Caparo is an investor buying these shares. Caparo depends on the accounts written by Dickman to give a true picture of the condition of Fidelity. After losing a lot of money, Caparo sued the accountants for negligence. Okay, so now the accounts were a true picture of the company, but obviously there were, as in all investments, unforeseeable consequences that caused a lot of money to be lost. So does Caparo have a case against Dickman? And here the judge said, well, no, there's no damages owed to Caparo because there was no duty of care to prevent the loss they suffered because it wasn't reasonably foreseeable. The consequences must be reasonably foreseeable, and it can't be reasonably foreseeable with just the accounts. If Dickman had said, you know, they will make money, definitely, we predict they will make money, that would be different. We guarantee they will make money. It would be different. But there were consequences that were not foreseeable, reasonably foreseeable. And this means that, you know, there is a duty of care, but the consequence must be reasonably foreseeable. Another example would be if I left my bag on the floor and a student fell over, you know, I owe a duty of care, I owe damages to the student, but then if the mother must look after the student because he's ill at home, you know, I can't be expected to pay the mother's wage or even the profit towards the mother's work because they're losing profit because the mother's staying at home, and any consequences that may have for the firm she works for, and maybe even suppliers' consequences for the fact that they're not buying. Yeah, it could be forever, these consequences, endless. So the principle here, it needs to be reasonably foreseeable. Now, we always use this word reasonably. The judges tend to, because they're coming up with what they think is good sense and not, you know, they're not making laws which, you know, are unreasonable. They must always think, what is good sense, common sense? What would be reasonable as a principle? So they use the language reasonable a lot because common law must judge according to a kind of intuitive common sense, cultural common sense, according to a general perspective of life. So we often see these reasonable, this word reasonable. Now, what are the advantages and disadvantages of common law over written law? There are advantages in the fact that, you know, by producing law quickly, you know, normally through Parliament takes a long time and it's very complex and it's a big process. But by producing law quickly, the law can evolve quickly, and we know things evolve very quickly in the modern world. If we think about it, you know, old inventions like the airplane, many years ago, if a farmer had a farm, he owns not just the ground, but also all the space above the farm, and an airplane, when they invented it, if it had to fly from Scotland to London, the pilot would have to ask the permission of all the farmers to go over their land. Otherwise it would be trespass. And that wouldn't be good sense. So, you know, the common sense was that they could just pass without having to, and maybe these farmers would say no as well, so it would become ridiculous. And we know, so just, you know, inventing the airplane really does change the situation. If we have to wait for a government to put all the infrastructure of the legal infrastructure in place before we can use the plane, it would be ridiculous. And, you know, with the inventions of social media and internet and telephony, you know, we do see that, you know, common sense is necessary because the law needs to evolve very quickly. So that's one advantage. Also, it's quite simple. You know, in the Italian common law, we've got to predict every tiny situation and apply these laws that are so complex and so difficult to follow in a language that's very difficult. So I think it does simplify it a little bit. It does also make it more predictable, because in England we really have to follow these principles, whereas in Italy every court is independent and can interpret law independently. They don't have to literally follow other courts, higher courts lead, if you like. They can have a new situation that's completely different and maybe interpret the law in their way. So it's less predictable in Italy. But in Italy we can say it's more democratic. So it is taken, you know, it is written by our representatives according to their political orientation, which was voted by us. We have actually handed down the sovereignty to these politicians to make these laws for us. And, you know, it could be that these judges don't necessarily make good decisions. They do live in a very different reality from the average person. What's reasonable to them might not be reasonable to the average person. Obviously, if they make some terrible decisions in the common law, then the politicians can change it. But maybe there's a lot of it's not so important a law, and they never get to analyse all the laws in such detail, and it doesn't get changed, or maybe not very quickly. Another important thing is it does save the politicians from a lot of work, which means, you know, they've got more parliamentary time to make big reforms or do other laws, and not have to spend so much time on every tiny detail of the commercial law. In England, we make much less laws than in Italy. In Italy, you make a lot more laws, and probably this means there's less parliamentary time to be spent on other things. So we can say there is a little bit of an advantage there.